Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about searching condo buildings. Cases that should have gone to the Supreme Court of Canada, but didn't. Frederick Wilson is a person who lives in a condominium building, and the police conducted surveillance on him because they believed he was involved in some illegal activity. It's not really relevant to the case. When they surveilled him, they didn't get a warrant, and they didn't surveil anything inside his condo unit. Rather, they used the common spaces of the condo building, the lobby, the elevators, the hallways, the shared spaces, to gather the evidence necessary to show that he was involved in illegal activity. He appealed his conviction at trial on the basis that the police did not have the right to surveil the common spaces of the condo building without obtaining a warrant, and that they violated his reasonable expectation of privacy in doing so. The court declined to grant him any relief on the appeal, finding that the common spaces did not have a reasonable expectation of privacy associated to them. He sought leave to the Supreme Court of Canada, and because his video is featured here, you know that that leave was dismissed. This case is really interesting, because modern life and the rule of privacy don't go together very well. Right now, the law of privacy in Canada deals normally with places that you have exclusive occupation or control, or the right to control or admit entry of others and not admit entry of others. In condo buildings, that doesn't happen. There are common spaces that are shared with sometimes hundreds or even thousands of other residents. And the privacy laws that Section 8 cases turn on were developed at a time when that wasn't the ordinary way of life for the majority of people. But now, especially as we're seeing huge multi-story residential developments in all of the major urban centers across Canada, that lifestyle is a reality for most Canadians. And so shouldn't most Canadians' new lifestyles reflect in our privacy laws? Shouldn't your Section 8 right to be free from unreasonable search and seizure be reflective of the way that you actually live? It doesn't make sense to say that a person doesn't have a privacy right within the walls of their condo building, but only within the walls of their condominium unit. And to limit privacy rights in this way is a really significant failure to recognize the realities of modern life, and a little bit, frankly, old-fashioned. The Supreme Court of Canada could have taken this as an opportunity to say, hey, privacy changes the same way everything else changes to reflect the realities of modern life, and we at the Supreme Court of Canada are not so old-fashioned to think that you only have privacy rights if you live in a house. Unfortunately, they declined to hear the issue, which means that police can basically set up and surveil people in a condo unit, and you, an innocent person, or maybe not an innocent person, may become part of that surveillance and become part of an investigation, even if you're not doing anything wrong. This is a significant concern. It's been a concern in numerous courts around the country, and it would have been nice for the Supreme Court of Canada just to say something about the issue. Unfortunately, until they decide that modern life needs to be addressed in our Section 8 considerations, we're going to have cases of police in the hallways of apartment buildings, and everybody should be careful. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has put together these videos for you, and I encourage everyone to like, subscribe, and share with your friends.